You have a permit, you followed the rules, you passed the background check, took the class, paid the fees, and you did everything right. But right now, in 2026, crossing into one of these 5 states doesn't make you a responsible gun owner. It makes you a felon. Most people think reciprocity works like a driver's license. If your state issued it, other states respect it. That's the conventional wisdom. That's what most gun owners believe when they travel. And that belief is exactly what's getting people arrested. Here's what's actually happening. The reciprocity map just collapsed. ConstitutionalCarry expansion, the very thing gun owners fought for, is being used as legal cover by anti-gun states to rip up their agreements with you. And in 2006, several states moved to do exactly that. I'm going to break down the 5 specific states, show you the exact felony charges you face in each one, destroy the myth that the federal Peaceable Journey Act will protect you, and give you a 6-step protocol to travel legally no matter where you're headed. By the end of this video, you'll know more about traveling with a firearm than 95% of permit holders in this country. Let's get into it. Point 1. The traffic stop scenario, how a broken tail light becomes a felony. Before I tell you which states to avoid, I want you to understand exactly what happens when you get it wrong. Because this isn't theoretical. This is happening to real gun owners right now, every single week. And the reason it keeps happening is because the scenario looks so ordinary that most people never see it coming. Here's the scenario. You're driving up I-95. You have a valid Virginia concealed handgun permit. Your firearm is holstered on your hip or sitting in your center console, exactly how you carry it home. You've done nothing wrong by Virginia's standards. You've done nothing wrong by any reasonable person's definition of responsible carry. You cross into Maryland. You get pulled over for a broken taillight. The officer runs your license. In some states, permit data is shared across law enforcement systems. He may already know you carry before he walks up to your window. He asks if you have a firearm in the vehicle. You're an honest person. You believe in being cooperative with law enforcement. You say yes. At that moment, in the state of Maryland, you have just confessed to a felony. Your Virginia permit means nothing in Maryland. The officer has no discretion here. This isn't a situation where a sympathetic cop can let you off with a warning. Carrying a concealed firearm without a Maryland permit is a criminal offense under Maryland Criminal Laws Section 4. 203. You will be placed under arrest. Your firearm will be seized as evidence. You will be charged. You will be transported, processed, fingerprinted, photographed, and booked into a Maryland detention facility. Now you're sitting in a holding cell, making a phone call to a criminal defense attorney you've never met, explaining to your family why you're not going to make it to dinner, and staring down a felony charge that, even if you eventually win in court, will cost you somewhere between $15,000 and $30,000 in legal fees before it's over. That is not a worst-case estimate. Criminal defense attorneys in the Mid-Atlantic region charge between $300 and $500 per hour. A felony firearms case easily runs 50 to 100 hours of attorney time, and that's for an uncomplicated case. If prosecutors decide to push, if there are multiple charges, if the case goes to trial, you are looking at significantly more. And here's what makes this worse. Even if your firearm is not on your person, even if it's in the trunk, unloaded, locked in a case, you may still be in violation, depending on exactly how it's stored and whether you're considered to be transporting through versus being present in the state. Maryland law draws a legal distinction between those two situations, and stopping for gas, stopping for food, or stopping at a hotel, even briefly, can push you from one category to the other. Here's the other dimension of this that most people miss. The arrest itself causes damage that a legal victory cannot fully undo. Even if you are eventually acquitted, even if your attorney successfully argues federal preemption or the charges are dismissed, your name has been in a criminal arrest database. Your employer may find out, your professional licenses may be flagged. Your carry permit in your home state may be suspended pending the outcome of the case. The legal victory happens months or years after the damage is already done. Maryland is not an outlier on this list. It's the example I use because of its geographic position. But the same scenario plays out in New York, New Jersey, California, and Hawaii every single week. The state changes, the permit changes, the result is the same. Now that you know what the worst case looks like, let's make sure you know exactly which 5 states trigger it. Now you know what the arrest looks like. But knowing which states to watch for is only half of it, because 2 of these states have penalty structures so severe, they'll genuinely shock you. Let's go through all 5. Point 2, the 5 trap states. Where your permit is legally worthless, In 26, these are the 5 states that have either eliminated reciprocity, significantly restricted it, or passed legislation in 2025 and 2026 that puts out-of-state permit holders directly in the crosshairs. Study this list. One of these may be on your travel route right now, and you might not even realize it. State 1. California has never honored out-of-state permits, but 2026 brought enforcement changes that make it more dangerous than ever for travelers. California's SB 2, which survived its most recent legal challenge in early 2025, dramatically expanded the list of sensitive places where firearms are prohibited, even for California's own permit holders. That list now includes parking lots of government buildings, public transit areas, hospitals, playgrounds, parks, stadiums, and anywhere alcohol is sold or served. For a traveler who doesn't know those zones, you can be in violation within minutes of entering the state, before you even reach your destination. You don't have to walk into a government building. You don't have to approach a school. You can be sitting in the parking lot of a restaurant that serves beer and be in violation of California law. Carrying concealed without a permit in California is a felony under Penal Code Section 25400. Penalty, up to 3 years in state prison. State 2. New York's Concealed Carry Improvement Act, passed in direct response to the Bruen decision, remains one of the most aggressive anti-carry laws in the country. In 2026, courts upheld the majority of its provisions. It is fully in effect, and there is no meaningful relief on the horizon. New York does not recognize any out-of-state permit, not one. And the CCIA's sensitive location list is so expansive that legal carry is essentially impossible in any urban area. Times Square, subway systems, theaters, restaurants that serve alcohol, any place open to the public for entertainment, all prohibited. What often surprises people about New York is how quickly you enter a sensitive zone without realizing it. If you're driving into New York City, you may pass through a transit-adjacent area, a park zone, or a commercial district with alcohol service within the first few minutes, and each of those is a separate potential violation under the CCAA. Carrying a loaded firearm in New York without a New York-issued license is a Class D violent felony under Penal Code Section 265.03. Penalty up to 7 years in prison. 7 years for a first offense. No prior record. Someone who simply didn't know the law changed. State 3, New Jersey. New Jersey's response to Bruen was to pass legislation so restrictive that the practical effect was unchanged. Almost no one can legally carry. New Jersey does not recognize out-of-state permits. Carrying a handgun without a New Jersey permit to carry is a second-degree crime under NJSA. 2C395. Second-degree crimes carry a mandatory minimum of 5 years with no parole eligibility for the first 3 years and 3 months. Read that carefully. Mandatory minimum. The judge cannot give you probation. The judge cannot suspend the sentence. If convicted, you are going to prison. No exceptions, no good faith credit, no first offense leniency. What makes New Jersey uniquely dangerous is its geography combined with its enforcement culture. The Garden State Parkway and the New Jersey Turnpike are among the most heavily patrolled corridors in the Northeast. Traveling from the Mid-Atlantic to New England means many people pass directly through New Jersey, and the penalties for getting it wrong are the harshest on this entire list in terms of guaranteed prison time. State 4, Hawaii. Hawaii's risk profile is unlike the other 4 states because the vector is different. You're flying in. If you don't understand Hawaii's laws before you board your flight on the mainland, you are in legal jeopardy before you retrieve your baggage. Hawaii does not recognize any out-of-state permit. Following Bruen, Hawaii issued new permitting rules, but the process is so restrictive and slow that no out-of-state traveler can realistically obtain one in time for a vacation or business trip. Carrying concealed without a permit violates Hawaii Revised Statutes Section 1349. Penalties include up to 5 years in prison and fines up to $10,000. The added trap is unique to Hawaii. State law requires specific written notification to local law enforcement before you transport a firearm into the state, even a legally owned, properly stored, unloaded firearm in checked luggage. If you have not contacted the county police department prior to your arrival, you are already in violation before you've left the baggage claim area. Most travelers from the mainland have never heard of this requirement. That's exactly what makes it a trap. State 5, Maryland. You already know what Maryland looks like from the traffic stop scenario. Here's the full legal picture. Maryland does not recognize out-of-state permits. The Firearms Safety Act of 2023 tightened enforcement significantly, and those provisions are fully active in 2026. Carrying concealed without a Maryland permit is a felony under Maryland Criminal Law Section 4203, up to 3 years in prison and a $2,500 fine for a first offense, escalating sharply from there. Maryland is the geographic trap on this list. Its position between pro-carry states on the East Coast corridor means thousands of permit holders drive through it every day, many of them completely unaware that their permit offers zero protection the moment they cross the state line. Law enforcement on I-95 and I-81 is aware of this dynamic. These are not corridors where you are unlikely to encounter law enforcement. These are some of the most actively patrolled highways in the country. That's 5 states. 5 states where your permit is worthless, the penalties are severe, and ignorance of the law is not a defense. Now, here's where most gun owners think they're safe and where they're most dangerously wrong. You've probably heard of the Federal Peaceable Journey Act. You probably think it protects you. It doesn't, at least not in the way you think. This next point is the one that surprises even experienced carriers. Point 3, the Peaceable Journey Act myth. Why federal law won't save you. Here is the belief that sends law-abiding gun owners to prison. The Federal Peaceable Journey Act protects me as long as my gun is unloaded and locked in a case. Here is the reality. 18 U.S.C. Section 926A offers far narrower protection than almost anyone believes, and the gap between what you think it covers and what it actually covers has real, documented, life-altering consequences. Let me walk you through exactly what the law says and precisely where it falls apart in the real world. Condition 1. The journey must be continuous and direct. Section 926A protects transporting through a state, not stopping in one. The moment you stop for anything other than a genuine emergency, courts in New York and New Jersey have held that your journey is no longer continuous, and the federal protection no longer applies. The Second Circuit Court of Appeals has upheld this interpretation. New Jersey courts have upheld it. If you stop overnight at a hotel, pull off for dinner, or stop for gas and go inside to grab a coffee, you are no longer covered under those states' courts. You are subject to state law. Think about what that means practically. You are driving from Virginia to Maine. It is a 12-hour drive. You stop at a rest area in New Jersey for 20 minutes. Under New Jersey court's interpretation of 926A, your continuous journey has just been interrupted. You are now subject to New Jersey law, and you are holding a firearm that New Jersey law says requires a New Jersey permit to carry. Condition 2, you must be legal in both the origin and destination state. Section 926A is not a blanket travel protection. It is a corridor protection for legal-to-legal travel. If you cannot legally possess the firearm at your destination under that state's laws, 926A does not apply. The definition of legal to possess is evaluated under the destination state's laws, not yours. This matters especially for firearm types and magazine capacities that are legal in your home state but restricted at your destination. Condition 3, the firearm must be genuinely inaccessible. The law requires a locked container not readily accessible from the passenger compartment. A locked hard case in the trunk, generally protected. A locked case in the back seat of a sedan, potentially not. A pistol in a locked center console. Courts have held this does not meet 926A's standard because the console is within reach of the driver. Many gun owners assume that locked is the key word. It isn't. Not readily accessible from the passenger compartment is the standard, and courts have interpreted that narrowly and consistently against defendants. Condition 4, and this is the one that matters most. 926A is an affirmative defense, not immunity. This is the single most misunderstood element of the entire law. Section 926A does not prevent you from being arrested. It does not prevent you from being charged. It does not require prosecutors to drop your case before it goes to court. It is a defense you raise after the fact, after you've already been arrested, processed, fingerprinted, and have spent thousands of dollars retaining a criminal defense attorney. The practical implications of this are devastating. In New Jersey, prosecutors have deliberately charged gun owners with felony weapons offenses, knowing 926A was a likely valid defense, because the financial, emotional, and reputational cost of fighting the charge was sufficient to coerce guilty pleas to lesser offenses. Documented cases, Real gun owners, people who were probably legally protected under federal law, who pleaded guilty anyway because they couldn't afford to fight, you could be completely compliant under 1926A and still face arrest, still face prosecution, and still face $20,000 to $50,000 in legal costs, because the protection only activates if you can afford to exercise it in a courtroom. The Peaceable Journey Act is a last resort, not a travel strategy. It is the emergency parachute you hope you never need, not the plan you build your trip around. So if federal law won't protect you and state law will arrest you, what do you actually do? Here's the exact protocol. 6 steps that eliminate almost all of your legal exposure, no matter where you're traveling. Point 4, the 2026 Reciprocity Collapse. Why this is getting worse, not better. Before I give you the 6-step protocol, you need to understand why this problem is accelerating, because what happened in 2026 is not the end of it. The trend line is moving in one direction, and you need to understand why so you can stay ahead of it. Here is the dynamic driving the collapse. Over the past few years, more than 24 states have adopted constitutional carry no permit required to carry a firearm. For gun owners in those states, that's a genuine win. Fewer barriers, less government permission required to exercise a constitutional right. That's the goal. But here's the dangerous side effect that gets almost no attention. When a state goes permitless, anti-gun states use it as legal and political cover to terminate reciprocity agreements, sometimes with dozens of states simultaneously. Their stated argument: if your state no longer requires a permit, we can no longer verify that your residents meet our training and safety standards. Is that argument legally sound? In most cases, no. Constitutional carry states didn't eliminate training. They eliminated the government mandate for it. Millions of responsible gun owners in those states still train, still practice, and still carry responsibly. The argument conflates permit required with trained and competent, which is not the same thing. But it doesn't matter whether the argument is legally sound. What matters is that it works politically. It gives anti-gun governors and attorneys general the cover to announce reciprocity terminations without looking like they're simply attacking gun owners. And the agreements disappear. Here's the compounding problem. The reciprocity databases maintained by organizations like the USCCA and the NRA are updated regularly, but they are not updated in real time. There is a lag, sometimes weeks, sometimes months, between when a state formally revokes an agreement and when that change is reflected in the tools gun owners rely on to check their status. That means the map you checked 6 months ago may show agreements that no longer exist. And because permit holders have no reliable way to receive direct notification when their status in another state changes, most people don't find out until they're standing at the side of the road being placed in handcuffs. This is the environment we are operating in right now. The reciprocity map is not stable. It is actively contracting. And the states most aggressively revoking agreements are the same states with the harshest criminal penalties. This is why the 6-step protocol is not a nice to have. It is the only reliable system for protecting yourself in a landscape where the rules can change between your last trip and your next. 1. The good news is that you can completely protect yourself from all of this, but only if you follow every step in this protocol. Miss one, and your exposure comes back. Here's the full system. Point 5, the 6-step compliance protocol, how to travel legally in 2026. This is the practical system. Follow these 6 steps on every trip, and you dramatically reduce your legal exposure, even in hostile states. This isn't complicated, but it requires discipline, because the mistake that ends your gun rights is almost always the one you didn't think mattered. Step 1. Run the reciprocity check before you leave, not at the state line. Before any trip crossing state lines, go to the USCCA's reciprocity map or the NRA's reciprocity database and verify today whether every state you're entering, passing through, or stopping honors your specific permit from your specific state. Do not rely on what you knew last year. Reciprocity changed in 2025. It changed again in 2026. It will change again. Check it fresh every single trip, as close to your departure date as possible. A check you did 3 months ago is not reliable. And check for your specific permit type. Some states have reciprocity with a standard permit, but not an enhanced one, or vice versa. The permit type distinction has tripped up experienced carriers who assumed their upgraded permit offered more coverage, not less. Step 2, route around non-reciprocal states. If your permit isn't honored, plan your route to avoid the state entirely, or plan not to carry during that leg. If you're driving up the East Coast and Maryland or New Jersey is in the way, you have two legal options. Don't carry through those states, or ship your firearm via a licensed FFL dealer to your destination and pick it up there. Both are legal. Both are significantly more convenient than a felony charge, a night in jail, and a 5-figure legal bill. This step requires planning. It is not something you figure out at the state line. Before you leave, map your route. Identify every state you will enter or stop in and make a deliberate decision about each one. If you're making hotel stops, identify which states those stops fall in. The planning happens at home, not on the highway. Step 3. If you must transit a non-reciprocal state, follow 926A protocol exactly. Unloaded firearm. Locked hard case. In the trunk or rearmost storage area, not the back seat, not the console, not anywhere accessible from the passenger compartment. Ammunition stored separately, either in a separate locked container or in the original factory packaging. And do not stop. Plan your fuel so you don't stop in the non-reciprocal state. If you absolutely must pull over, treat it as a genuine emergency, stay in the vehicle, do not exit, and if possible, document the reason. Every single element of that protocol matters. The firearm must be unloaded, the case must be locked with a key or combination lock, not a zip tie or a cable that can be cut. The ammunition must be stored separately, and the storage location must be out of reach from the driver's seat. One element is missing, and your 926A defense becomes substantially weaker. Step 4. Know your duty to inform obligations before the stop, not during it. Duty to inform laws, which require you to notify law enforcement that you're carrying when you're stopped, vary significantly by state. In some states, it's mandatory and immediate. In others, there's no requirement at all. And in non-reciprocal states, the calculus is still different because the permit you're carrying may not be recognized. Before traveling through any state, know exactly what you are and are not legally required to disclose. Consult a firearms attorney if you're unsure. What you must not do is volunteer information about a firearm without a legal obligation to do so, especially in a state where that disclosure becomes an admission of a crime. Step 5. When flying, follow TSA and airline protocol to the letter and notify local law enforcement if required. Unloaded firearm, hard-sided locked container in checked luggage only, declared verbally at the check-in counter before bags are tagged. TSA-approved locks, ammunition in its original factory packaging, or a purpose-built ammunition case stored separately. And if you are flying to Hawaii or any other state with a law enforcement notification requirement, contact the relevant county police department prior to your arrival, not after landing. Prior means before you board the plane. Arrests at airports in New York, New Jersey, and California have resulted from people who followed the TSA protocol perfectly, but did not understand that state law imposes additional requirements beyond what the federal checkpoint demands. Federal compliance and state compliance are not the same thing. You need both. Step 6. Document everything and carry proof of compliance. Keep a physical copy of your carry permit in your wallet, not just a digital version on your phone, which can be locked or dead when you need it. Carry your firearm's bill of sale or registration. If you're traveling under 926A protocol, carry a printed copy of 18 U.S.C. Section 926A and a one-page summary of the storage requirements. None of this creates legal immunity, but it demonstrates good faith, it speeds up your attorney's response when they're building your defense, and in some cases it has made the difference between a prosecutor choosing to pursue a case and choosing to move on. This is also why legal defense memberships from organizations like the USCCA or Second Amendment Foundation have become standard equipment for anyone who travels with a firearm. One wrongful arrest in a hostile state can generate $20,000 to $50,000 in legal fees before you ever enter a courtroom. If you travel regularly with a firearm, that coverage is not optional. It is part of your carry kit. Let's bring it home. You came into this video knowing you had a permit and thinking that was enough to protect you across state lines. Here's what you know now that most gun owners don't. You know the 5 trap states: California, New York, New Jersey, Hawaii, and Maryland, where your out-of-state permit is legally worthless and the penalties range from 3 to 7 years in prison with mandatory minimums that even a sympathetic judge cannot reduce. You know that a routine traffic stop in the wrong state with one honest answer to one question can make you a convicted felon before you make it to your destination. You know that the Peaceable Journey Act is a courtroom defense, not a travel pass, and that it only protects you if you meet every strict condition and can afford to fight it in front of a judge. You know that the reciprocity map is actively shrinking, that it changes without notice, and that checking it once and trusting it forever is how good people end up with felony records. And you have a 6-step protocol that, if you follow it consistently, keeps you legal no matter what the map looks like. That is the difference between carrying with confidence and carrying with a clock running out on your gun rights. Subscribe to GunsLawGuide. I break down exactly this kind of complex, constantly changing gun law every week, so you are always operating on current information, not assumptions that expired months ago. Next video, the 5 duty-to-inform states where not telling a cop you have a gun is itself a felony, and the exact words you need to say at a traffic stop to stay fully legal. That is required viewing for anyone who carries on the road. See you there.